Imagine you bought your dream home, quiet street, stable ground, but the developer starts digging next door. Not just digging, but 9 meters deep excavation. You start noticing your driveway tilting, cracks forming, power poles leaning. You complain, council steps in, but nothing changes. Then one day, your land collapses into your neighbor's side. Your home becomes worthless. When you attempt to argue, the builder said to you, "Lawyers and courts don't worry me. They are like cockroaches to me, and I can walk away from all this without paying a cent." And when you sue, the company is bankrupt, the builder is gone, and you are left chasing individuals who are physically involved in excavation. This is not fiction. This is exactly what happened in Brown and 𝗷cie developments, and later in the Court of Appeal. Today we break down what a homeowner feared most, who should take responsibility if the builder and the developer went into liquidation, how compensation is calculated if damaged property isn't worth a penny. This case is described by Justice 𝗀𝐿𝐿 of Supreme Court of New South Wales as a homeowner's worst nightmare. The plaintiffs are Mr. Brown and Ms. 𝗀𝐿𝐿. Mr. Brown is an electrician who works as a lift mechanic. Mr. Brown and Ms. 𝗀𝐿𝐿 own a business which repairs and alters motorcycle leathers. They bought a house in Gosford in August 2015. The property is a battle axe block. The driveway runs uphill from 𝗷cie Street along the rear of a number of other properties before reaching the couple's house and the carport. They bought the house so that it would be easier to load and upload equipment from their van. They were also hoping to build a shed as a home workshop for their business. Unfortunately, their home sits next to a large apartment development. The architectural drawings were prepared for a building comprising 3 6-level buildings with over 50 apartments and over 60 car spaces. The development site was owned by a development company named 𝗷cie Developments Pty Limited. The developer engaged a builder, namely Newtech Constructions Pty Limited. By the time of trial, the developer 𝗷cie had been in administration, and the builder Newtech was in liquidation. So the plaintiffs also sued the individuals behind the project. Those individuals were the members of 𝗀𝐿𝐿's family, who ran or worked for the builder Newtech, including the director Frank 𝗀𝐿𝐿, his uncle Nick 𝗀𝐿𝐿, his father 𝐀𝐻𝐿 𝗀𝐿, and his brother Alex 𝗀𝐿𝐿. Although Frank was the sole director and shareholder of Newtech, it became readily apparent that he was a puppet. He had little knowledge of the affairs of the construction company. It was Nick who mainly ran the show. He was a consultant for developers and named himself as project manager. The father of Frank, 𝐀𝐻𝐿, was the licensed supervisor. Nick and 𝐀𝐻𝐿 asked Frank to be the director, as each Nick and 𝐀𝐻𝐿 being either the project manager or licensed supervisors had clear conflicts of interest. Frank had no clue, did not even know where the company's registered office was. Even worse, it turned out that Frank was disabled and was a bit illiterate. That fact itself is troubling to start with. Before construction even began, a geotechnical engineer warned in 2015 that excavation of the development site posed a high risk of landslide. It required a depth cut from 6 to 11 meters, especially along the boundary with Mr. Brown's land. It would expose fill and cause ground movements. In particular, the geotechnical engineer identified possible landslide hazards to the existing slopes, including failure of the 25 to 45-degree slope along the western boundary, supporting the adjacent land's driveway. Recommended solutions include installing CFA piles that will give deep structural supports, stabilizing the soil before excavation, and imposing ground movement monitoring. For example, beaching and battering is a simple and effective method for controlling the risk of ground movement and collapse. Battering a slope involves creating a step or inclined gradient instead of a vertical cut. It provides a more stable and secure excavation environment, minimizing the risk of landslips and ensuring the safety and longevity of the construction project. But what actually happened? The developer and builder ignored the advice from geotechnical engineer, failed to stabilize the boundary, failed to comply with council's conditions of development approval, and excavated close to and beyond the boundary. Over time, driveways started tilting and small landslip occurred. There's one detail that is important. To the south of the couple's home and uphill is 𝗷𝐿𝐿 Reserve. Along parts of the southern boundary exists a concrete drain which collects surface water runoff from the bushlands to the south. In heavy rain, water ran down from 𝗷𝐿𝐿 Reserve onto the property would be diverted by the concrete drain away from the house. But one of the first things done by the builder was to break up the existing drainage channel. When recalling what happened, Mr. 𝗷cie said this: "I was standing on the corner watching 𝐀𝐻 breaking those concrete things were meant to scoop up the water from the hill. This was all crushed. He said he was going to make it nice and pretty." In October 2017, Mr. Brown took some photos indicating that after digging by the builders, there was a large quantity of tiles discovered near his house. This was a bad sign, because the presence of tiles in fields suggested that the land was subject to dumping rather than a controlled field. This could potentially weaken the stability of the soil. At this moment, some further testing should have been done to prepare an alternative design solution, but no steps were taken. By December 2017, the site had been stripped of vegetation and tiles had been stockpiled. From 2019 to 2020, the concrete slab of the driveway started to move, and cracks in the walls can be seen at the eastern end of the house. At the same time, Newtek was celebrating of signing an $18 million contract for the rest of the construction. From 2020 to 2021, Mr. Brown and Ms. 𝗷cie complained to the council and mayor's office, but little was done, and the damage to the property became more obvious. The window in the living room rattled when the front door was closed. Cracks were seen in the internal G-block sheets. Gaps appeared in the panels of the roof eaves. The slabs in the driveway were noticeably tripping towards the development site. In March 2021, 𝐀𝐻 thought it would be a good idea to buy the couple's house. The parties negotiated a deal of $670,000, but no contract was signed. At around the same time, the soil around the power pool had been washed away. 𝗷cie had to disconnect the electricity supply, leaving the couple without power. They even had to buy a small camping stove to heat their meals. Nick, on the other hand, denied that it had anything to do with the excavation and said that it was a leaning power pool that was old and rotten, so it had to be replaced anyway. From April to May 2021, Mr. Brown and Ms. 𝗷cie engaged a lawyer to seek rectification works or push for the property to be sold for $670,000 by the builder or developer. There was no reply. The excavation works continued in September 2021. In November 2021, the rainfall reached one of the highest recorded monthly average. The land collapsed, trapping Mr. Brown and Mr. 𝗷cie motor vehicles. The concrete sections of the driveway had actually slipped down the embankment, some 6 or 9 meters down. Mr. Brown could not even drive his work car or 2 motorbikes off the property. Property is effectively worthless. On 1st December 2021, Nick said to the couple that not to worry, as the developer was responsible for rectifying the damage. But on the same day, Alex operated excavator on the site again, just below the landslip area. He was told by 𝐀𝐻 to dig away any wet soil and tiles in the area of embankment where the slip had occurred and use hard rock and sandstone material from other boundary of the site to backfill and stabilize the land. In January 2022, the couple complained to the council again, and they did not believe the builder knew what they were doing, and they were asked to off when speaking with 𝐀𝐻. New South Wales Fair Trading were also involved to issue notice of remedial works. In March 2022, the house began to shake like an earthquake. In June 2022, the builders performed further excavation works on the couple's property, placing steel bars on the ground and pour concrete onto the land. This was done without requesting access and without geotechnical engineer's approval. The builder was requested to leave, but refused to do so until police was called. The owners had to obtain judgment to restrain the builders from entering to the property for further works. The damage brought lots of inconvenience to the couple because they ran a motorcycle leather repair business. They had to give up the idea of building a shed as a workshop. They also had to park their cars in the street, which is 100 meters away, and carry gears up and down the driveway. Their vehicles had been vandalized while parked on the street. These caused the couple a lot of stress over 5 years. Mr. Brown and Ms. 𝗷cie eventually commenced proceedings, seeking damages for trespass and negligence to make good their land, driveway, house, and carport. Now let's look at the parties' arguments. The plaintiff's case is that they argued negligence on part of Nick, 𝐀𝐻, Alex, and Frank due to failure to take reasonable care and ignoring known risks. They also pleaded trespass because of excavation went beyond boundary and physically interfered with their land. They claimed costs to fix land and house, loss of access, and general damages. The 𝐀𝐻 family members argued we did not cause it by denying responsibility for collapse and challenging evidence linking their work to damage. Nick, in particular, argued that he was not obliged to review the geotechnical reports, that contained key recommendations. He said to the court that this document is not for Newtek. Nick further stated that the document is for reference to the engineer, not to me. Nor did Nick accept that anybody reviewing the geotechnical reports was on notice that there was a high risk that the driveway would collapse. 𝐀𝐻, on the other hand, said that the only thing he looked for was the permitted hours of operation of the site, and he announced, "I don't need to look at other things." When he was asked whether he read the development approval attached to the building contract, 𝐀𝐻 said no, not really. For a builder of 40 years experience, 𝐀𝐻's evidence was found by Justice Rees as unbelievable and unacceptable. Even when facing the pictures clearly showing the driveway collapse, Nick described that as a movement and did not consider that a serious matter. Nick even said in the hearing, "We are talking about an area that's 5 meters wide, so I don't believe that to be serious." In addition, Nick said the collapse had nothing to do with the builder, but was caused by a 1-in-100-year storm. 𝐀𝐻 agreed with Nick and said that the collapse of driveway was due to tiles dumped by others that were underneath of the house. He confidently alleged, "My materials did not collapse." Lance's family also argued, "We did not trespass." They argued no proof of crossing boundary and said they didn't knowingly enter plaintiff's land. In particular, 𝐀𝐻 said he did the excavation work but did not went over the boundary. Nick also contested that despite a number of witnesses seeing him operating excavators on the boundary, those witnesses did not have photos, and the memory was not reliable for events occurred 3 years before. They also pointed fingers to others who should be responsible. They tried to rely on proportionate liability and blame other contractors. Lastly, they argued damages are too high. They said that compensation should be based on diminishing in value, which is about $745,000, not rectification costs, which could be $2.1 million. So how did the court cut through all this? Firstly, the judge made it clear that even though a company existed, individuals were liable because they controlled the works, acted as de facto directors, and personally directed conduct. Importantly, Justice Rees noted that a person not formally appointed as a director of a company may still be considered a director if they act in the position of a director. This is consistent with requirements under Section 9(a)(c) subsection 1 of the Corporations Act. Nick was cross-examined at length. Justice Rees found that he was an intelligent man with a keen eye to where his interests lay. Nick offered self-serving statements when the opportunity presented itself. He accepted no wrongdoing or fault on the builder's part. Nick was argumentative and evasive. Nick was on site every week, dictating how things were to be done, but describing himself as an employee and answer to the company director Frank and then to the on-site supervisor 𝐀𝐻. He was caught out in lies, and he clearly was the main person in charge. As a result, the judge did not accept Nick's evidence unless it was against his own interests or corroborated with other reliable witness or contemporaneous document. Considering the size of Newtek, the roles performed, duties played, and outsiders' perception, the court was satisfied that both Nick and 𝐀𝐻 were de facto directors. The court found no risks of landslide, clear engineering warnings, and no proper precaution being taken. The court particularly noted that Nick had the geotechnical reports for some time before building contract was signed. Nick's responsibilities was ensuring compliance with planning instruments, and 𝐀𝐻, as a supervisor, must familiarize himself with the geotechnical reports and conditions of the development approval. Both Nick and 𝐀𝐻 were on notice that the risk of a landslide was high, but failed to take any steps to minimize erosion and sedimentation and address the natural watercourse and stormwater flows along the boundary. In response to Nick and 𝐀𝐻's excuse that the driveway collapse was due to heavy rain or tiles underneath, the judge endorsed the expert's evidence that if they had followed proper procedure, such an event would have been prevented. The court implied that there were many opportunities that the builder could have rectified the works, especially when the first landslip at the power pole, but little had been done for over 5 years. The developer and builder's conduct in this regard were negligent and in breach of the duty of care unto Mr. Brown and Ms. 𝗷cie. As to the trespass, the court held you don't need to know the exact boundary if you physically enter land or excavate into it. That's trespass. During the proceeding, Alex said, "I wouldn't even know where the boundary was. No one showed me any pegs to show where the boundary was, so I don't know if 𝐀𝐻 dig past it." The video recording also showed that somebody was shouting against Nick, saying, "You had the pegs down 6 weeks ago, and they are all gone. You threw them out." There is also concrete evidence being the survey plan recording encroachments onto Mr. Brown and Mr. 𝗷cie land. During construction, security fence was erected on the couple's land, and Nick admitted that it wouldn't stand up in thin air, implying that the builder had crossed the boundary during construction. The trespass is proven. Importantly, it was established principles that where a director trespasses on land on behalf of the company, the director is personally liable. Not only that, the court noted that a director is also personally liable if they direct the company to commit a trespass. Lastly, damages is a major issue. 𝐀𝐻 submitted that the rectification cost was excessive, as he could fix the problem with 3 cubic meters of concrete and a few sheets of mesh. He even said the cost wouldn't be more than $4,000. The court completely rejected this argument. In order to reinstate the land to the condition prior to the commencement of work on the development site by Newtek, it was necessary to construct a retaining wall along the western boundary sufficient to reinstate the right of the support for the couple's land, and to construct a new driveway providing access and extending to the carport. The fact that the property was subject to high risk of further instability, could not be redeveloped, could not be accessed by a vehicle, and could further deteriorate due to ground movements, caused further damage to the house. The refilling works would cost from approximately $2 million to $3.5 million. The house repair would cost about $66,000. As the diminution value of the land, it will be approximately $700,000, because the property currently worth about $75,000, while it would have worth at least 10 times more if the structural defect did not exist. The court eventually assessed the rectification costs at $2.17 million. Because the property was the plaintiff's home, they are entitled to the greater of the rectification costs or diminution value. Fairness requires restoration, not just the market value loss. While the plaintiff could sell their house and buy another, the usual analysis would that person purchased their home to live in because they wanted. The consequence is that Frank, Nick, and Alex were required to pay 70% of the compensation, being $1.5 million, and 𝐀𝐻 was required to pay 30% of the compensation, being $650,000. Alex and Nick appealed. Alex's argument was that he was a truck driver and a hammer operator, that he did not materially contribute to the damage to the couple's property. Also, there is no finding that Alex knowingly entered onto the land. Nick, on the other hand, argued that the trial judge should not apportion 70% liability among himself, Alex, and Frank, and did not add 𝐀𝐻 into the equation. He also challenged that the rectification costs are disproportionate to the diminishing value. The matter was heard by the Court of Appeal before Justice Christine Adamson, Justice Anna Mitchmore, and Justice Julie Ward. Appeals were dismissed. The Court of Appeal upheld liability findings. The judges made it clear that the trial judge was entitled to reject Nick and Alex's evidence and adopt the evidence, including video footages, concluding that they did operate excavators and removed uncontrolled fill at the boundary. Nick and Alex were liable because they earned a duty of care and they failed to take reasonable precautions. The reason why 𝐀𝐻 was 30% liable while other three were 70% liable was because 𝐀𝐻 pleaded proportionate liability in his response, but not the other individual defendants as concurrent wrongdoer. For trespass, intention was irrelevant. As to damages, relief based on valuation of rectification is still appropriate. If that turns out to be more expensive than the value of diminution, the wrongdoer has no one but himself to blame. So what does this mean for us? First, developers must take risks seriously. Ignoring expert advice would result in massive liability. Builder was obliged to follow recommendations of geotechnical engineer, as they had expertise in relation to the stability of the ground, while the builder did not. Number two, you can sue individuals in certain circumstances. Even if company collapse, directors and controllers may be personally liable. Number three, compensation can be huge. You may recover full repair costs, not just the value loss. However, there are a few things that trouble me. It was somehow surprising that Frank, being disabled, is still liable, and no discount was allowed because the court said that a defendant who inflicts harm on another by unreasonable conduct is not excused from liability in negligence because of reduced personal capacity. This case also demonstrated a systematic flaw in construction industry. That is, even geotechnical engineers made recommendations on substantial risks. It will still be up to the discretion of the project manager to seek further consultation and make the final call. It was also not clear in this case how counsel did not seek to modify the conditions of the consent and issue construction certificate for the excavation despite various risks. So let me ask you, do you think the council should be responsible for such event? Should disabled Frank, with little knowledge of the builder's affair, be held liable as much as Nick and Con? Should directors be personally liable when construction companies fail and go into liquidation, leaving defects unrectified? Let me know your thoughts, and don't forget to like, subscribe, and follow us for more Australian legal breakdowns. Thanks for watching. See you next time.